So a landmark judgment there. Will it be a turning point in the country's fight against corruption? Well, joining me tonight, I'm joined by Chandan Mitra, Rajya Sabha MP of the BJP. I'm also joined by Mr. R.K. Raghavan, former CBI director. With me in studio, Vineet Narayan, the man, the original Hawala case petitioner. Also with me, Kiran Bedi of Team Anna. And I spoke earlier tonight to the law minister who gave the government's official reaction to the verdict. I began by asking Mr. Khurshid, who's in Lucknow, that in the middle, of course, of the Congress releasing the UP manifesto, came the bad news for the government in a way on the Supreme Court judgment. And I asked Mr. Khurshid that the BJP says this is a moral indictment of the government and the Prime Minister.
Well, I find it interesting that the BJP seems to have got hold of a copy of the judgment that we haven't yet read, because the copy of the judgment would be available only once it's signed. The pronouncement in court was only of the operative part. As I understand it, there is no indictment whatsoever. All that the court has done is to decide a principal point of law and given indication as to what the future should be like. In fact, suggested that Parliament should amend the law to provide for a very tight three-month or a 4-month limit on deciding to give sanction or not give sanction.
But Mr. Khurshid, the judgment is actually out on the website. You may not have had time to read it so far because you're in Lucknow, but it does very specifically make the point that the Prime Minister was ill-advised. It slams the fact that Subramanian Swamy's plea actually had to go to A. Raja, the Ministry of Telecom, who was the man who was being accused by Subramanian Swamy, and then to the Ministry of Law as well. Again, it was delayed. The actual delay is 16 months. They say the Prime Minister is ill-advised, but they've come down hard on the PMO officials. They've come down on the Law Ministry, the fact that this went to A. Raja. How do you defend that?
Well, I can understand, but that's not an indictment of the Prime Minister. That, in fact, is an expression of faith in the Prime Minister. But every day in and day out, the courts are disagreeing with what government has done in the manner or the content, and the courts are always telling government, you can't do it this way, you can't do it that way. That's what the writ jurisdiction is all about. That's what most of the work of the Supreme Court and the High Courts is. So why should that be a setback? If we weren't going to set our prestige on, we will not decide within a reasonable period. Now, if the court feels a reasonable period is 4 months, and they want to indicate that in a judgment, and they say that as far as they are concerned, that the time taken in the past, for whatever reason, whoever gave the advice, the time taken was excessive, should not be permitted, there is no problem there at all. Why should there be a setback?
No, because Mr. Khurshid, isn't it a moral setback, given the facts of the case, that the Prime Minister's office took 16 months for this prosecution to be cleared? The Supreme Court now says it should be 4 months should be the time. Isn't that a moral embarrassment?
It's not moral setback, because the Supreme Court hasn't said that you should have done it in 4 months. The Supreme Court has said that you must now in future do it in 4 months. Isn't there a difference? Isn't there a difference in prospectively telling you to do something in the context of the past, of course, but to prospectively tell you to do something and to say that this is what should have happened in the first place? Now, let us assume that the Supreme Court has given 4 months and the Prime Minister's office had taken only 5 months. The Supreme Court still could have said 5 months is 1 month too long. Do it in 4 months. So ultimately, something that you're looking at forward, prospectively, is something that's obviously announced and pronounced by the Supreme Court, acceptable to the government, with full sincerity. And we will either implement it on our own, or if we feel that the safer thing to do is to implement it by changing the law, we will change the law as well.
Well, that was Mr. Khurshid speaking to me earlier today. But let me just open this up to my panel. And of course, I have Vineet Narayan here, the original Hawala petitioner. And Mr. Narayan, one contradiction of what Salman Khurshid just said is that, of course, the Supreme Court had already said that there should be 3 months time limit for sanction in the Hawala case.
I think Mr. Khurshid has forgotten that in the original judgment in 97, Supreme Court had given the direction that 3 months should be the maximum period to take time for giving permission. But you see, in 2003, when the CVC bill was drafted by the NDA government, they ignored all these directions and then they brought back the single directive. So the whole direction of the original judgment were diluted, and that led to this problem. Successive governments have been sitting over the cases of corruption. There's a whole long list of CBI applications. CVC's website has more than 40 names that includes IAS officers and income tax commissioners against which no permission has been given. I don't think this is an event where somebody can take political mileage out of it, because both BJP or Congress governments have suppressed permission in these matters. So I think what Supreme Court has done is reinforced what they had said in 97, appeal to the parliament to pass suitable legislation, and of course given right to a citizen, fundamental right to file complaint against corrupt officials.
NDTV's cricket app, Android and iPhone, fastest scorecard, special analysis and much more. Download free. ndtv.com/apps.